Hello, everyone, and a warm welcome to the latest edition of Napthens' legal podcast, Debrief. Um, my name is John Esner. I head up Napthens' commercial and regulatory team. If you wonder what that is, it's basically contracts and law, what it says on the tin. Now, in this episode, we're going to be looking at the importance of intellectual property, IP. And I guess that's a term that we hear a lot of these days. So we're going to be looking in particular at what IP is, and what part it can play in particular in business acquisitions, how it's dealt with when you're buying or selling your business. To help me do this, I'm going to be joined by my colleague Adam Turley. Adam's a legal director and head of our intellectual property team. And I guess one of the things about Adam is that he is a real expert in this area of law. He has many years of deep experience. And I think that's going to be very helpful because Adam can take us through not just the background law, but some of the experience he's had. So, Adam, I think to kick off, I think we probably just need to clarify what IP, what intellectual property, what is it? How does it differ from other kinds of property?
Yeah, thank you, John. It's good to be here with you today. So, intellectual property, the main difference, it is a piece of property, so you can deal with it as you would any other piece of property, but it protects more intangible things as opposed to bricks and mortar and what have you. When we talk about IP, we're talking about four main areas. We're talking about trademarks.
Mhm.
Most people have heard of trademarks. Most people have an idea of what trademarks are. Trademarks they can protect many different things, including quite random things like smells and colours and the like. But generally, with trademarks, we're talking about protection of company names or brand, product names, and logo names.
You brand, so it's key, really, isn't it?
Yeah.
It's what you are, what it says on the
Exactly.
tin.
And it's
Yeah.
what is bringing customers to you.
Yeah.
It's your reputation, and it's a protection of your reputation. In addition to that, we've got patents.
Mhm.
Again, that's something most people have heard of without necessarily knowing what it is, because I get a lot of inquiries from people who think they need to speak to me about a patent and they don't. But a patent basically protects new and inventive things. That can be products or that can be processes, ways of doing things. What people often need when they talk about patents is the third type of IP, which is design right. And design, where patents protect how things work,
Mhm.
designs protect how things look. And designs can be either registered or unregistered. So patents have to be registered. Trademarks ideally are registered. You can rely on something called passing off if you don't have a registered trademark, but for various reasons that I won't go into, it's not ideal. And then the last of the four different types of IP we're talking about copyright. Now, copyright generally protects creative artistic things.
Mm.
So people will have heard of copyright in the context of Ed Sheeran being sued and Taylor Swift being sued and all that type of thing.
So it's like artistic
It is.
productions.
Yeah, but it's also still very relevant to businesses. So the copyright can exist in things like software codes, websites, the layout and the content of websites, marketing materials and photographs that go with them, and things like customer lists as well. They are all things that can have copyright in them. And copyright is an unregistered right. So where you can register trademarks, patents, designs, you can't register copyright.
Right.
At least not in the UK. You can in certain other jurisdictions. It just exists. As long as the qualifying criteria are met, when you create something, it is protected by copyright at that point.
Okay. So I guess to summarize, we've got trademarks, which is essentially your badge.
Yeah.
Very important, what everybody knows you as. Patents, which is the rights in your key inventions. So again, absolutely critical and of great value to the ongoing performance of your business. Designs, which, as you say, relate to the appearance of that, and copyright, which is non-registrable, but essentially it's anything that has been produced and includes, I guess, for example, code, as you say, software
that's
code.
often a big one.
Yeah.
Yeah.
So if you've got a key piece of software that you've produced and is a sales product for you, it's very important there.
Yeah.
Or I guess if you're reliant on a piece of software as well to perform your business that you've obtained from someone else, it's important to confirm who owns that and that, importantly, you have the right to own that.
Definitely. Yeah. No doubt.
Okay, so I guess thinking, I suppose, of some sort of critical issues around all those potential rights. What happens if you register, if you just take a sort of a broad approach and go away and sort of register things, but then you don't actually use them? Is that a reasonable strategy, a sort of ultra cautious strategy you could adopt?
Yeah, definitely. It depends on the right that we're talking about. So with patents and designs, there's no, if you don't use them, that's fair enough. The key here though is around trademarks. So I always advise people to register a trademark as early as they can. You don't want to spend a lot of money on marketing materials and the like and promotional strategy, and then find you can't use the trademark. So I tell people to register as early as they can. But the key with trademarks is we have something that we call use it or lose it.
Right.
So you have a 5-year period after you first register your trademark to start using it. After that point, if you're not using it, other people can apply to cancel it. So it's important for business owners to have that in mind, particularly if they're moving, for example, towards a sale.
Yes.
Then if the trademark is part of that sale but you're not using it, it's of limited, potentially at least of limited value to the purchaser.
Yes, so I suppose you can't just go out and register things and chuck them in the back cupboard and forget about them. If you don't actually use them, if you don't need them, someone can pop up and say, right,
Yeah, exactly.
You're not using it, I want that.
Yeah.
Yeah, I mean, obviously you mentioned there potential of a business sale. I mean, we've both got experience of dealing with IP on business sales. So if you are a business owner and you're seeing potentially you're moving towards that aim of a disposal, of making good your investment, what are the kind of questions that you need to be asking yourself? And I think, and also what kind of issues have you seen arise sort of unexpectedly once this process has started?
Well, that's it. It's unexpected. And I try to tell people to head this off before you start the process. So if we take as a starting point, if we take trademarks again, A, are you using the trademarks you've got? But B, and probably more importantly than that, have you got the trademarks you should have? So is your company name trademarked? Is the name of a logo of your most popular product or service offering trademarked? So a couple of years ago now, I got instructed by a clothing company that were starting the process of a sale. And one of the questions they got asked, which, as you know, is in every single due diligence process, is around trademarks. And did they have a trademark for their company name? And the answer was no. And so they came to me and they asked me,
is that the first time that they thought
yeah,
about
they'd been trading 20 years or so. And they came to me and they asked me, can we get trademark for our name? So I had a very quick look and I saw something on the register that was can't remember if it was identical. It was very, very similar to what their company name was. And it was highly likely that that company would oppose any trademark application that might be made.
Right.
Now, the person I was speaking to had grounds to then challenge their trademark application and what have you. But the point is,
Yeah.
as you know, when you're going through a business sale,
It's not an ideal
no,
context, is it, in
no.
which to be trying
So
to make this right?
they were left with the choice of either applying for the trademark and potentially having to tell the buyer that they were in litigation over their very company name, which is one of the main assets that the buyer is looking to purchase, or just go back to them and say no, and you're going to have to take a view on it. So that is an absolute key point here. If you've got any, even the most in the future plans to sell the business, you need to ask yourself that: have we got everything trademarked? Can we get it trademarked? And then, like you say, you also think about use. You have to think, if there's more than one company, who owns the trademark? Is the right company or the person using it? Those type of things. If you then think about, if we then move on to patents and what you need to think about with patents in business sales, does the company have any? Not, I mean, it's often something that companies don't have, to be fair. What territories have you got it in? Is there anywhere else you should be looking to get your patents? Are all the maintenance fees paid? And are there any potential issues around employee compensation? Because if employees contribute towards patents and you derive a benefit from that, there is a scenario where
Right.
employees can pursue you for additional compensation above and beyond their
Okay.
usual
Right.
the usual remuneration.
Right. So that's if they worked in developing
Yes.
those patents.
Yes.
Okay.
Yeah.
Right.
Yeah.
So again, not an ideal issue to
No,
be negotiating when you're
It's
trying to
something
sell
that
your
you
business.
want to
Yeah.
know about, definitely. And then designs, many of the similar considerations with patents. Do you have registrations? Because there are registered and unregistered designs. Are your renewals up to date? Are your core products protected? Do you have any new products that you should be looking to register? Are your designs valid? A lot of people don't realize that there's only a 12-month window to register designs from when you first market them. So people will look to register them at a later date and actually not realize that they're not valid, things like that.
Oh, right. Oh, so if you miss that, you
Well,
missed
you
the
still-
boat, have you?
You can still have the registration, but it's a very limited value
Okay.
because it's not really enforceable, because the other side will just say, well, you weren't in that time period. And then copyright, again, is all of that work, is all that copyright work owned by the business? And that actually is a real key point that it's really important to stress here, is the provisions around ownership of copyright and of design right. Mainly it's copyright is the key here. But people think that they own the copyright in what they have. And a lot of the time they do, but it depends on who created it. So if an employee's created it in the course of employment, then yeah, the company owns the copyright. However, if you have instructed a third party, for example, a web developer, or
Very common scenario.
yeah, exactly, to develop your website for you, or a software developer on code, unless you have a written agreement with them, they will own the copyright in what they have done for you. And a lot of people do not realize that. And again, I came across an issue where I was brought in to assist with a sale, and it was a company that offered, it was employment software, and that was its product offering. And it turned out that certain parts of the development had been done by a third party, and not only a third party, but a third party based overseas. So it wasn't clear cut that the company owned the copyright in the software that they were looking to sell.
And again, this was the first time that they had
Yeah.
focused on that
Yeah.
issue.
So we'd done an assignment of various other bits of IP that were in the business, but then we had to instruct lawyers in the country where the software developer was based to also assign his copyright in that country. And
Right.
there was no issues with him doing it, but
Okay.
we were already through the sale process and it very nearly went off.
Yes,
So
I can imagine managing external lawyers and
yeah.
trying to get a third party to assign something to you when you're up against it is not
Yeah,
again
and
is not
again,
an
people
ideal scenario.
often don't understand why they're being asked to do it. So it's something else that you should look at when you're, well, really when you're ever instructing a third party, a contractor, but definitely when you're thinking about selling, it's another aspect of getting all those ducks in a row.
So thanks. So I guess to summarise, if you've actually done it yourself with your own employees, then in principle you're okay.
Yeah.
But the moment you contract with a third party,
Yes.
not to mention, especially if that third party happens to be in another jurisdiction,
Yeah.
then you need to be clear in your contract with that person that they assign it to you so that you own it. Okay.
Definitely.
That's what you're paying them for. Okay. Good. Yeah, quite a few points there to bear in mind. So I guess just generally then, from the perspective of a business owner, you've spent 20 years at the cliff face building up your business. You're now coming towards realizing your investment. You may be sort of on the point really of going to the market. You may even have gone to the market. What are the key points, do you think, then, that you need to be focusing on as that owner, as that business seller?
Yeah. Well, the two absolute key points are the ones that we've already discussed. That is the trademarks. Have you got them? Can you get them? And again, are you using them? Is the right entity using them? Or do you need to put licenses in place and things like that? And the ownership point on the copyright side of things, again, those are the two absolute key points. But then you also look at registering other things like the designs. For example, if you're a company that makes things, that produces things, slightly outside the area of IP, but it's something that comes into it, is things like domain names for the businesses. Do you own those? Quite often they'll get caught up in IP assignments as well. And the other thing is, do you export, for example? And if you do export, do you have your IP rights sewn up in those territories where you export?
Right.
Because that's an area of vulnerability if you don't. And also, it's worth considering your competitors, the marketplace. Is there anybody who is potentially copying you or your product? Or worse, is there a risk that those sort of allegations may be made against you?
Right. Okay. So I guess that could go both ways as well, couldn't
Yeah,
it? You could have somebody who is pirating your ideas, but at the same time, someone could pop up and allege that in fact they own the rights that you think you've been happily using for the past 10 years.
Yeah. So
Yes. Yeah. A lot to think about. So I guess that's from the perspective of the potential buyer. So I suppose what about now from the purchaser? What about from the perspective of the buyer? The person who is now looking to acquire this business, who has identified it as a good investment, but who wants to make sure that while paying, in most cases, a pretty hefty sum for what they're acquiring, that they're going to get what they think they're getting, and they're not going to get a load of problems that goes along with that. What do they need to think about?
yeah, I mean, a lot of what they need to think about is the same, just looking at it from the other point of view. So, do they have those trademarks? Use becomes very important. You don't want to buy a trademark that's susceptible to being cancelled. Do they own the rights? Like I say, a lot of it is actually what we've been talking about, but just flipped around from their point of view. And for them, a lot of the time, it's stuff that comes up during the due diligence process. But what they can do before that, when this sort of, maybe it's even before they get into putting forward offers or negotiating heads of terms or whatever it may be, is they can be looking at registers, trademark registers, design registers, have a look at the business as best as you can through the website or whatever it may be, and try to identify yourself where the IP rights are. So trademarks, like I say, you can pretty much identify what should be the core trademark. So you can then go and investigate whether they're registered, who owns them. Is it the company? Is it the directors? Is it somebody else entirely? And you can see whether licenses are in place.
And it's often the case, isn't it, that there's a director or somebody closely involved in the business who actually owns
Yeah,
it and lets the business use it
exactly.
rather than the business
And if
itself.
that's the case, is it even included in the sale? It's not. The director of the selling company doesn't always want to give up the brand. It depends on the context. And yeah,
it's a point for negotiation, I
it
suppose,
is, isn't it?
it?
It definitely is. But then, yeah, you do that sort of initial thing, but then a lot of it for the buyer comes down to the due diligence, and you then hope that the seller has sort of looked at the things we've discussed so that it's all there and all the documentation can just be handed to you and say, look, everything's in order. That's what you're getting. There you go.
Yeah.
And the job's
done.
Yes,
exactly. You've got what you wanted.
Indeed.
Yeah, I mean, I think we've all had calls, although I think that probably back in the past now, when a buyer 6 months later finds out that in fact they haven't acquired what they want, but as you rightly say, if you have a decent, if you have a properly organised, properly managed due diligence process, that should not happen, and that will not happen. You will know what you're getting.
Well, that's it, isn't it? And if you've got any questions around the IP, because IP, it is a bit of a niche area, it is a bit, then the key is just to speak to somebody early and get those issues identified as early. The earlier anybody identifies them, the easier they are to deal with.
Yes.
You don't want businesses setting a deadline to complete and then saying, well, hang on a minute, we need to sort out these trademarks or this software coding, who owns it, those type of things, because they can throw a real spanner in the works at that late stage.
Agreed. Yeah. As ever, the earlier the better.
Yeah.
Well, thank you very much for that. I think that was a fascinating, I guess, and very detailed discussion just on, I guess, the basics of IP, what it is, all the different components, how we protect them, how we prepare to how we maximise our value there, and also how we're likely to deal with them on a disposal. I think probably just in summary, I think the big points that I probably take away from this are that intellectual property can and often is crucial. It's a key part of value to your business. And a problem arising can be the difference to a sale proceeding or not, especially if something unpleasant comes out during the joys of a due diligence process and a negotiation. And I guess also, secondly, and sort of linked to that really, is that it makes the difference between what you realise on your investment. If you're protected, you really are putting yourself in the best position. If you're not protected, if you're being forced to deal with these, to sort of, as you just said yourself, sort of trying to manage through a process with lawyers in other jurisdictions at the last moment, then you do run the risk of losing significant value. Did you have any thoughts as well on your sort of key takeaways?
I think you've summarised them very well. I think if I was going to give, and I risk repeating myself here, but my key takeaways are get those rights registered where you can.
Yes.
A registered right is so much easier to deal with in any context, whether it's litigation or the sale of a business or even investment. It doesn't have to be an outright sale, it can be investment as well. It's just so much easier when you've got a piece of paper that says this is what you own, this is what it is. And then my other key point again is, and I can't stress it enough, is that ownership point. On the sale of a business, that obviously is absolutely key. You can't sell something that you don't own.
No, and you don't want to find out that you don't own it
At that time,
in the worst possible circumstances.
Exactly. Yeah. So those are my two sort of key takeaways from this.
No, thank you. Well, as I say, I think that was a sort of fascinating tour through a lot of aspects of intellectual property. We hope that those joining us also found that interesting. Napthens clearly offer a lot of services to business owners. If you would like to see more on that, please go on our website and have a look. We hope that you found this discussion with our subject matter experts useful, and we very much hope that you'll be able to join us again for the next edition of this podcast.